Jeff Kravitz and Bob Cohen from the Beverly Hills Bar Association's ADR Committee. We are very pleased to have with us here today two accomplished forensic accountants, Michael Kaplan and David Golbahar. Their kudos are in the materials that have been provided to you. And we're going to be exploring with them today how best and worst to use forensic accountants in mediation. And I thought it was always good to start out with a happy story. So, Michael, maybe you can briefly talk with us about one instance where you were retained and how nicely it went.
The one instance that I was retained in, that is one that's generally at the top of my mind when I address the issue of mediation. It was a mediation of a family dispute. Their brother and sister, they were in business together, a business that their father started. And at some point, sister became very unhappy with the way her brother was running the business. Brother was the manager. So she brought a suit against the corporation, filed for a dissolution of the corporation. And brother and his family responded, and it was their intention to buy sister out at the fair value of her interest. The court appointed 3 appraisers. I was one of the 3. Each side selected one appraiser, and then the 2 of us agreed on a neutral. So there, one selected by the plaintiff, one selected by the defendant, and a neutral. We went through the process, and it was a very, very difficult process because these people were at each other's throats. But the neutral and I came up with the same number for the value of the business, which was about $3.7 million. The plaintiff's appraiser, the appraiser selected by the plaintiff, came up with a number of $6.6 million. There's a little difference there. The court affirmed the number that I came up with and the neutral came up with. The plaintiff took the case up on appeal, and the appellate court, in its infinite wisdom, referred it out to mediation. The mediation was in San Francisco. I got up to the mediation venue. I was invited to be there. All of the appraisers were invited. The neutral was not there. I, as the one selected by the defendant, was there. The appraiser selected by the plaintiff was there. It became very apparent to me that the attitude, that everyone came there with the attitude that the other side is not going to come around and see it our way. And if they don't come around to our line of thinking by 10:30 in the morning, we're out of here. And I know that there's so many parties who will go into a mediation with that mindset. This is a waste of time. We're here because the court ordered it. Well, 10:30 came and went. My people were still sitting there. The plaintiffs group, they were in their caucus room. About noon, the defendants said, look, let's all go out to lunch. We'll have a nice lunch. When we come back, if the plaintiffs haven't come around to the way we see it, we're out of here. And we came back, and time went anyway. That we were there for a little while in the afternoon. Now it's 3 o'clock, and I'm realizing that my people are getting ready to go. They mean it this time. They're not going to stick around longer unless someone keeps them there. And I'm thinking to myself, each side has spent $1.5 million on this litigation, and it's a family. Christmas dinner is not the same as it had been in years past because brother and sister are at each other's throats. So at about 3 o'clock, I'm sitting in the room with all the defendants and their attorneys. And I looked up and I said, I have an idea. And they all kind of jumped up. And I said, let's look at each of the 4 issues that's before the appellate court. And let's put a probability on whether the court will rule in our favor or rule against us. And they provided me with those probabilities. They got working on it. And then once we had that, I said, okay, now if the case is remanded back to the trial court, what do you think is the high, the low, and the most probable number the trial court's going to come up with? And they gave me a high, a low, and a most probable, and we put probabilities on that. And I multiplied it out. That 3.7 million turned into 4.1 million. The next time the mediator walked into the room, I said, go back to the plaintiff's room, get them started in this type of process. Maybe we can make some headway. To make a long story short, and I can go on with this story for the whole day, but to make a long story short, we started this process at 3 p.m. These people were at each other's throats in litigation for 6 years. By 5:30, the ink was dry on the settlement conference, on the settlement agreement, I should say. Ink was dry in the settlement agreement. And what happened, what I realized that I had done is I got the people off of being just ensconced in their particular positions and focus their attention on how can we get, what number would settle it? How do we get it settled? And they did. And it was a happy ending for the parties because they would have each spent another 1.5 million and wouldn't have gotten any farther along and would not have had a better outcome.
That's a great story. So in a sense, you kind of assisted the mediator in the process of settlement.
That's right. The mediator was running back from room to room with his frying pan, banging everyone over the head. We've all been in mediations like that. But what we needed to get the parties focused on the process. I knew what the numbers were. And, explaining the numbers to the people in that type of setting isn't going to get us any further along. It was a matter of getting the parties invested in the process of looking for a resolution.
That's very interesting. Now, I've got a question for you, Michael. You've been doing this for decades. I'm sure you've been in numerous scores, if not more than that, of mediations as an expert. And of course, you've testified at trial. What types of mediations are you involved with? Family law, business dissolution, personal injury, economic loss, and also, are your analyses and reports different for a mediation versus trial? Are they more simplified, or is it the same type of work product you would have for a trial?
Great question. First of all, the work that I do, the mediations that I've been involved in, pretty much parallel the type of practice that I have. They're primarily business litigation. And there's some employment litigation in there. Occasionally, I'll take on a family law case. Those become even more challenging in the mediations, but they're typically business-related cases and different kinds of economic damages, lost profits, whatever the case may be, business interference. When I go to a mediation, I'm fully prepared to walk into the courtroom and give testimony as if I was being put on the witness stand. And typically, the mediations that I've been involved in have been scheduled at a date after I've been, after I have finished my work. Usually it's after my deposition. And then there's a mediation where the parties are attempting to get a resolution to the case. I was just speaking last week. I was speaking with a retired judge who's in the ADR practice in Maryland, and he was telling me when you have a mediation, everyone's got to be sufficiently prepared in order for that mediation to be productive. You don't know where to go if you don't know where the numbers are. So my belief, and it's a strong belief, is when I walk into mediation, I want to be prepared to take that case into trial, even though my objective is different in mediation from what it is in trial. But when I walk into that mediation, I want to be well-versed in the facts and the evidence, in the approaches, and in the work that the other expert did. And I want to be in a position where if the other expert, if there is something about the other expert's analysis that I believe that he and I or she and I can sit down and gain more clarity as to what the other one did, we can together guide the numbers to a point that makes sense for settlement purposes.
Does that happen very often?
David, give it,
Well,
I'm sorry.
Does that happen frequently or infrequently when the two competing experts come to a consensus when there's a dispute?
When the process of the two experts coming together, whether it's before the mediation or during the mediation, I mean, there have been times that I've turned to my retaining counsel and asked, can I take the other expert in another room? And I've got a few things to talk about, and I think we can move it along. But those happen quite often where I can have an audience with the other expert. Those situations, they happen when they happen. I mean, you know, I can't say they happen a high percentage of the time or a low percentage of the time. It just depends upon the particulars of the case.
Yeah.
David, tell us a little bit about your practice, how it varies by category, if it varies, how you get used differently maybe in a family law dispute as opposed to a piece of business litigation.
Sure. I think in the context of mediations, those have happened more along the lines of personal injury cases and employment cases. The similar to Michael's experience, I'm also focused on business litigation. Those cases, I think, because it's more, we're talking about methodologies or different assumptions, when we come together, those seem to be resolved across financial experts, I think, more easily than when it's emotional, like family law. So I've also participated in family law mediations as well. And similar to, although it was a business dispute in Michael's case, when it comes to family, I think emotions take over, and it prevents, at least what I've seen, the parties really coming together and reconcile. And so that's really I've seen it, at least in not as many mediations, but in the cases I've been in, the parties, and it's also up to counsel really to bring the parties together.
I have a
Well,
question.
and I want to ask the two of you, kind of the secret sauce for what we're doing today. And let's start, David, we'll start with you and then to Michael. What do you think is the best way for lawyers and accountants to best prepare for mediation together?
So similar to what Michael said, we come in and we're prepared as if we're going into trial. So my schedules, the analysis is set up for essentially completion. I've been in matters where they're like, well, we have a limited budget, please just do a limited set or a limited analysis. And those are the ones that really hurt, because if it's not done all the way to a T, you're setting yourself up for what could be a disaster, or at least not a strong mediation. And that's where I think experts and counsel need to work together to say, look, our goal for mediation is really to come together and settle this. I think that's really, and the secret sauce is having counsel and experts that work in tandem together, having all the facts. I've seen the other side come in and have blinders on without having all the facts together. And that hurts the mediation itself, because and I think Michael has a great story about this, when the other side does not have everything, and then you come together and they're like, well, if you had this piece of information, would it change your answer? And that sometimes becomes yes.
Michael.
What? Oh, okay, go ahead.
I have a couple of things to add to that, and that was great, David. Thank you. if you have a mediation too early in the process, you don't have all the facts. You don't have all the evidence. The expert has not had a chance to evaluate it, to interpret what does it mean. And I know that there are situations where in certain jurisdictions, they schedule mediations very early in the case when the parties aren't ready. Well, you can't settle it then. Yeah, you need to have experts who know what they're talking about, who have the facts, who have the understanding. And I prefer that the mediation is farther along. I prefer that it's farther along in the process when earlier we're not going to have what we need. But at that point where the experts have what they need and they've done what they need to do, then you have the mediation as soon as possible, assuming, of course, that the issues that the experts are there for are the issues at the heart of the case. But if the experts are prepared, I know whatever the case may be, if David and I are on opposite sides of the case and we've done our work, you could put the two of us in a room and we're going to come up with a proposal that will work for everyone. That certainly some variation of it will work for everyone. But if we don't have all of the facts, we don't have all the evidence, haven't had a chance to evaluate it, do our research, it really erodes the value and impact of that mediation.
And Michael, I want to actually kind of, I think, build on an assumption. I've prepared for mediations where we are not in the room or not a part of that process outside of providing schedules and a report. So Jeff and Bob, when we are involved, and I'm happy to participate in those conversations, because when we're not there, if a mediator has questions, I've been on call, but the impact of having both experts on there to be translators, financial translators, or to at least reconcile certain differences, I think that's what really is the key, because both sets of counsel want to advocate for their client's position. We as independent financial experts will have the objectivity to bring in and say, look, on these areas we can come closer together, but there really is a legal question or a fact question on these areas where we cannot reconcile. And so I think having us in the room is the secret sauce, and being able to help the mediator shuttle between the rooms.
Sounds really right on, because information and mediation really and communication is everything. I've got a question for both of you. Have either of you been in a situation where there's a dispute between the accountants and the mediator sides with the other accountant expert? And if so, what do you do in that situation? How do you handle being told either directly or indirectly that you're wrong?
I have an answer to that one. It's a mediation. The mediator is not the judge. The mediator is not there as a judge. I will pull my retaining counsel aside and tell her or tell him the mediator is wrong on that. And this is why. This is not like being in a courtroom and giving testimony before a judge or testimony before a jury, and what comes back from the trier of fact is just wrong or out into left field. This is a process where everyone participates in the process. And I would, if I knew that I don't want to put myself up on a pedestal, but if I knew that I was right and what the mediator came up with was just wrong, I'm going to tell my retaining counsel. I'm not doing my job unless I tell retaining counsel, look, there's a problem with what the mediator is proposing. It's a problem with it.
I
And I'll
think
say, "Why?"
similar to Michael, I don't think I've been in a situation where a mediator has come out and said, David is wrong or the numbers are wrong and so forth. But it's also part of the process to help communicate clearly to the mediator that position. So I think I've seen mediators do a great job of, I don't understand, please help me see what you're seeing, and then let me kind of bring that to the other side. So I think it's not necessarily, I guess the wrong is the word that I didn't like in that question, because I from what I've seen, that everyone tries to come together. Um, and I guess the experts I've been opposed to, it is more, it's not like something is necessarily wrong. It's either there's missing information, a difference of opinion on methodology. So those are the ones where I can speak to. Now, kind of transitioning it to special situations where we couldn't bring the other side together. When one side has a retained expert and the other side doesn't, those I've seen more likely fail, because opposing party that doesn't have an expert doesn't have the acumen or an objective person to help them come together. And that's where I've been involved. I guess one of my war stories is on a healthcare M&A where I was retained by the buyer, and the seller disputed the earnout, and the accounting methodology the owner used was not something that was generally accepted, was not something that was within the contract, and the numbers just did not make sense. The mediator was able to see that. The mediator brought that and explained it. I was actually luckily to be I was one on call for. And unfortunately, so this is where ego and emotion really affects Excel, is that the other side was unable to at least see and understand and say, okay, we hear you, but we disagree because we like this number. It was just a flat out rejection. And that one failed. So, and I felt terrible about it.
Jeff, you
Well,
have a question?
have you ever gone in the other room with opposing counsel and the other side's client to mano a mano chat with them and explain what you've done in your methodology?
I've offered it. I am an open book, because I do see myself as someone who has to communicate the methodology, the facts, and the figures that we're seeing to both sides equally. So it's the same explanation that I would give my own client is what I would need to explain to the opposing counsel, and that's what we do at the end of the day in a deposition or in a trial. So in the mediation, it's the same explanation that we're giving. I guess it just has, we're just trying to make everyone to come together at the end of the day.
I agree that we're trying to make everyone come together. And that's the objective of a mediation. We're trying to get the case resolved. And, with that as a premise, I will go into the room. I will go into a room with opposing counsel, with opposing counsel's client, with the other expert, whoever it is who needs clarification, if it will assist in the process of bringing the parties together. That's why we're in mediation. Okay, this a mediation. It's not like going into a courtroom and trial. You've got a trial. There's a judge there. There's a jury there. The experts get up and they give testimony that's built around the home run number. The home run being, supported by evidence and the expert's judgment. But you go into mediation and the parties, certainly the attorneys know, you're not going to get your home run number in a mediation. There is going to be some give and take. And as experts, we need to be able to explain the realities of the variables and the pieces that go into whether the number should be a little bit this way or a little bit that way, or this should be out or that should be added in.
Well,
It's
that's
just,
a good segue, and I'll ask each of you, how much do you work with the clients themselves, which may have in-house accounting capability as opposed to working through the attorneys? And maybe a war story or two would be good here.
Sure, I think it all depends on the case. More on the business litigation side, the fact finding happens with in-house accountants, CFOs, to pull the data that we need. And I think, for some of the employment or PI, so employment, you're pulling the information based, if it's an individual, their numbers. And then on PI, it's also, I guess, what we've been given and the situation there. So there is more in-house, I think, within commercial litigation on the business side, but family law, employment and PI, it's more with the with counsel.
I have a question. Well, go ahead, Michael, and then I'll pose my question.
I usually look to the attorney to get his or her preference as to whether I should be dealing directly with his or her client or employees of the client company, or should I be going through counsel for everything that I need? And there are issues of discoverability but I will look to counsel for direction on that. At the beginning of the case, I'll be very, very clear. I'll have clarity with counsel.
Okay. Are you ever retained, either of you, as the single expert CPA for purposes of mediation only, realizing that your findings are not binding, but they're looking to you for advice and to save some expert costs?
I've been retained jointly by the parties, but not specifically for mediation. I've been brought in as a joint expert or even as a court-appointed expert. But again, the end game in terms of the thought process of the attorneys and the objective that I had was to prepare and take the case through trial. If there's a mediation along the way, that's so much better. That just adds an opportunity to get the case resolved.
Yeah, I think similar to Michael, I don't think I've been retained solely for the purpose of mediation. Mediation has been a product of the litigation process. So we'll step into it as the case moves forward.
Okay. Yeah, go ahead.
If an expert is brought in just for the mediation, you're looking at something that could have a very, very significant cost to get you to the mediation. If the expert is brought in to be an expert in the matter, in the lawsuit, with an expectation or with a likelihood of going to trial, and mediation is a step along the way, the marginal cost of having the expert involved in the mediation is not that big.
Okay. Yeah.
And it's likely to be less costly than not having the expert in mediation.
Have you ever dealt with situations where you basically were in a conflict with your retaining attorney over your evaluation or analysis, and yet still were able to participate in the mediation? How did you work through situations like that?
Are you suggesting that counsel's opinion was different from my opinion?
Yes. Basically, counsel once says to you, look, put your thumb on the scale. I don't like what you've done. Where do you go then?
I give counsel a list of other experts that he or she should.
Yeah, I think Bob, we definitely see that. Look, council's advocating a position, but I think very often we see we come in as objective and ethical experts, and we can't become advocates for counsel's position or the client's position. So I always appreciate those debates. But like Michael, if we, if they don't like what we have that we're presenting, we're not the right fit. And so I will happily excuse myself, and Michael's on my list. So
Have you been in situations where you've had to withdraw on ethical grounds? Can you
I have.
share some examples?
I just tell counsel, I can't do it. This is what you're asking me to do is not my opinion. My opinion is different from the number that you want, and it's different from the number that you want me to testify to. And when I swear to tell the truth, the whole truth, and nothing but the truth, I'm gonna tell the truth. I'm gonna give my opinion.
Well, I'll jump in with a quick story, which is I had a piece of business litigation, and it was a 7 and maybe an 8-figure case on the plaintiff side. I hired reputable accountancy firm to do the analysis, and back before Zoom, my expert demanded or requested a face-to-face meeting. And I came in and I said, "What's up?" And he said, "I don't want to say this guy's books are cooked, but they may be microwaved." And for one example, he said he's deducting his wife's lingerie as a business expense. Well, this was a medium-sized business where the guy's role was law within his company. So I went to my client and I said, we got a couple of issues here, not the least of which is your wife's underwear on the books. And his attitude was that if she was going to grandiose company functions, he was entitled to deduct those. Well, and I said, and maybe with the IRS you can win that battle, but we're either going to have to amend the books or we're going to have to find another expert. And I don't think we can find another expert who's going to hold up in court. So reluctantly, he agreed that that would come off the books, but it was a real fight. It should not have been, but it was a real fight.
And I've seen similar situations where there is a disagreement. For me, it's uncomfortable, but I guess it has been necessary where we have to educate. Look, if we advocate a certain position, like as Michael said, we swear an oath. And if we have inconsistent testimony, that's where it first goes. Like, if I have to go on the stand and talk about this, my prior case that I had a different opinion, different methodology, opposing counsel is going to rip me apart. Is that something you'd want me to face? And usually that realization and that discussion helps us reconcile more towards our objective point and kind of what we are set out to do to help at least present the financials in these complex situations.
Do you ever go into joint sessions to present your position with the other expert present as well, or is it always done separately, shuttle diplomacy style?
I would prefer to have the other expert there. And I've been in situations where we have presented together and presented in the presence of the other expert. I mean, I had a situation, and this was a number of years back, where there was a huge difference between my number and the other expert's number. And there was a mediation, and I attended the mediation, and so did the other expert. And what I realized at the mediation is the other expert did not have all of the evidence.
Wow.
He did a good job, did an excellent job with what he had, but he was missing a big chunk of the evidence. I turned to my retaining counsel. I said, is it okay if I take the other expert into a conference room and sit down and talk to him? I think I can get through all of this. We can resolve our differences. I took the other expert into the room and I showed him the additional evidence that he didn't have. There was a lot more evidence in the deck. And he looked at it and I could see, his eyes really got big. And he said, he was, very, very surprised. And I looked at him, I said, if you had had this evidence when you did your work, would it have changed your opinion? He said, yes, it would have. I said, well, let's see what it would do. And right there, I had him go through and update his numbers, factoring in all of this other evidence that we had. And it was in a format that it was easy to grab the relevant numbers. And somehow miraculously, his number was so close to mine. I mean, they were within pennies apart. And when I realized we both approached the case the same way. We both had the same objective. What was missing is he didn't have all the evidence. So the more opportunity that I have to work with the other expert, the better off everyone's going to be.
Do you know why the other expert didn't have all the information? Was the attorney working with that expert stacking the deck and intentionally withholding information?
You just hit one of my hot buttons, because I've seen that time and time again, where the attorney has withheld evidence that he or she knows will harm their client's position if that evidence comes to light. Yeah.
Yeah.
What do you do? What do you do?
What do I do? Well, I never take another case from that attorney again. It's someone I know that I can't trust.
Bob, I always
I
ask
had a
for
case in
more.
trial. I was in trial. It was a small case. My number was $93,000. I was the defense expert. The plaintiff's expert was $158,000. The court-appointed expert came in at $125,000. That case should have never gone to trial, but the jury came back with a verdict of $700,000.
Oh my God.
And the case settled the next day for $900,000.
Wow.
Okay. And it all revolved around some evidence that neither I nor the plaintiff's expert had. It was this evidence that was being hidden, but opposing counsel had that evidence and introduced it in court. And it was just a disaster for a lot of people.
Wow.
And that's a very big lesson that I've seen throughout the tenure of my career, is when counsel either cherry picks information or withholds information, it leads to issues down the line and ultimately doesn't serve the client. So if we know what we have in front of us, and that's why a few key points that I drill with all the attorneys I work with is hire us early on. Hire us during pre-litigation where we can help you with discovery, because that helps with that information. If we are working in tandem, the ultimate result is better. When it comes to, I think on the valuation side, and Michael, it seems like you've done a few appraisals. When we don't have the evidence, if we're cherry picking and it's more of a art than a science, then there could be big differences. And so that's where having everything in terms of all the information, all the facts upfront and early will help you in mediation and in trial.
What
Why
do
do you think? Go ahead.
Okay, go ahead. All right. What do you do? And I'm sure this happens occasionally. Hopefully not too often, because I know you both handle bigger cases. What do you do when your attorney client tells you we're running out of money and you've done a lot of work and They're trying to salvage the situation. Maybe the client's not going to go into bankruptcy, but for whatever reason, they're running out of money. What do you do in that situation?
I mean, I hate to say it. I'll take the case to finish because I believe in getting it done. So more often than not, we'll figure it out in a way that's a win-win for everyone involved. Michael, what do you see?
I agree with you. I mean, it all depends upon the circumstances leading to their running out of money. It becomes more problematic when the attorney or the client owe you a lot of money. You've got a big outstanding receivable, and then they come back, and now you're thinking, now you're realizing that you're on a contingency fee arrangement, even though that is a departure from professional standards by having contingency rate. But sometimes things.
Yeah, de facto. Yeah, it's a de facto contingency
Of course.
rate.
And by the way, an expert, when I explained to my retaining counsel, you don't want me on the witness stand if I'm in a contingency arrangement, because if I'm on the stand and you or your client owe me money, what the message that puts into the jurors' minds is that my compensation is dependent upon my testimony, notwithstanding that it's a departure from professional standards. But you don't want me on the stand under those circumstances. So my answer to the question would be different if the receivable had been managed properly and they just got to the point where they'd paid everything up to the current bill, and they say, okay, we're at the point we're running out of money. We've got to do this on a limited budget. I mean, I had one where I was court appointed, and I got involved in the case, and I discovered that the subject company's books were a mess. On a good day, under the nicest thing I could say is they were a mess. And I came back to them and I said, to clean up the books and records, to get them to the point where I could even approach valuing the business, this is how much money it would cost in terms of accounting fees. And one of the parties ran to the judge, or they both ran to the judge, and the judge said, you know what? I can't authorize that kind of fee. This is the amount of money that I'm going to direct you to pay Mr. Kaplan, and he's got to come up with an opinion within that scope. And then what I did was I brought counsel together. I had a meeting with both counsel without their respective clients, and I said, look, this is what I could do within the scope of that budget. And I laid out what I could do. I said there's certain assumptions that I would have to make. Certain assumptions that I would have to make without going through the process of really cleaning up their books and records. I'd have to assume the tax returns signed under penalty of perjury were accurate, a reasonable reflection of their income and expenses, and all the financial information was reasonable. And there were certain other things. I said, if each of you agrees and your clients agree, and I want that in writing, that you will agree with these following assumptions, then I will come back with a number that will put you in a position where you can get this case resolved. And that's what we did. But when those things happen, they have to be addressed proactively. When money is an issue, we have to step back and say, what can we do? What can't we do? And it also depends, and I think David would agree with me, that it depends how far along in the case are you. Are we just talking about that last segment, or are we just getting involved in an enormous amount of work? I mean, it's a different case, it's a different matter, it's a different decision.
Right. I think I've seen that more often than not happen towards the end, because Bob and Jeff, I think when we are being retained, there is a discussion around the economics. More often than not, if I see that the numbers don't make sense on the face, or like that case you're talking about, Michael, where it's less than $100,000. Well, whether we're doing an analysis that will result in 1 million or $100 million of damages, the process is the same. It still takes time to go through the data, to analyze it and produce a report. And unfortunately, if it's a smaller amount, risk management will, in my head, the game theory and risk management dictates maybe an alternative path. So I'm happy to put myself out of a job if we know that the economics won't make sense. On the flip side, where it might be a smaller dollar amount, but the work still matters, happens in, I think, white collar. So criminal defense cases where you don't want that charge, and restitution's not a big deal. That's where we'll work, and the budget will exceed what restitution could be.
Interesting. Hmm. The whole thing about mediation is interesting today because it's so popular compared to the way it was 5 or 10 years ago. And of course, even 20 years ago. Do you find that there's a higher percentage of settlements in the mediations that you're involved in now versus what it was maybe 5 or 10 years ago? Is there any change in that?
I'm looking up because I'm processing. I think more often than not, the mediations I've been a part of have not settled, and have gone to the next step. And I think that's more of parties and what they're trying to do. And like what Michael said, sometimes I think mediation's happening a little too early. And so if it's too early without willing parties to really want to reconcile, and it's just like something we have to do to build the case, then more often than not, it doesn't work out.
You've never gone back to the judge through the attorney saying it's too early and that they need to extend the time to complete the mediation? Have you ever done that? Because that is a problem now, early mediation.
I haven't counseled attorneys on timing just yet. I'm trusting that they know what they're doing at this point. But I think now I have a takeaway from this call, from this webinar, that maybe recognizing that and having some alertness falls onto the shoulders of the experts as well.
We've got about 10 minutes to us, and I thought I would throw out for each of you, the question is, what has been your most challenging assignment in a mediation, and how did you handle it?
I think it's the largest challenge I faced was that one case where I'm the only expert and there isn't an expert on the other side. And that becomes difficult because of the other side, may not have the acumen or the willingness, but when experts come together, we more often than not can, essentially we speak the same language. So I'm able to say, here's where I'm coming from. I see where you're coming from. Let's see, to Michael's point, is there any evidence that's missing that will drastically change the same methodology that we're using? Or, do we say, I see what they're talking about and to retain counsel, and here's a way we could come together. So I think that's my biggest challenge, is not being able to communicate with someone else that understands what we're doing in the other room.
The most challenging situation that I've had in mediation is when counsel tells me that I should not participate in the mediation because his or her client doesn't want to spend the money. And first of all, in most cases, that's being penny wise and pound foolish, especially when they're earlier mediations. Just think about what the cost is if the mediation is not successful. The cost of if the difference between the mediation being productive, successful, and the parties come to an agreement, take the cost of having the expert there and compare that to the cost of the mediation falling apart and then having to continue the case all the way through trial with all of the risks that go along with it, or continue it to another follow-up mediation. And my philosophy is I will never let the cost of having me there get in the way of my being invited to the mediation. And if it's a mediation that I should be attending and participating in, I'm going to attend and participate. I mean, unless I'm directed, no, we're not going to let you in the room. But for the most part, if there's a mediation, the expert should be there.
Jeff and Bob, actually, I want to pose that question to you. Have you been in a mediation where the experts were not in the room and you wish they were?
Yes.
Yeah.
Yeah. And, I think Michael pinpointed it, that it was a question of money on the part of my client. And, we've kind of alluded to this, which is the ethical dilemma. My expert was willing to come gratis. And that does present an ethical dilemma that you guys have pointed out, where it looks at that point like a one-way contingency. And I ended up in my particular case having the expert there because I thought that the benefits of this person being there, let's just say they outweighed my ethical concerns. And I felt that I had an obligation in the first ethical dilemma to serve my client, and that my client was better served having that person there with what minute risk there could be down the road of an accusation that he only would be paid if we won the case.
Interesting. I don't disagree. I have found in the last 10, 15 years, experts are more often involved in mediations, both outside of the session and in the session. I've always felt that experts brought a wonderful added informational element to the process, whether it was an accountant or somebody else, an economist, or even an expert physician. In the past, I think mediators have been, reticent to spend much time with experts, but I do think that's changing, and I think that that's for everyone's benefit. That's my take on it.
Yeah, I think at the end of the day, having us in the room prepared and working in tandem with counsel and the client really pays off. And I think that's kind of a great ending note. It's that we work as teams, and so being able to take our work and explain it and communicate it so that the parties can reconcile is really the most important thing.
David, can you think of a situation where there is no upside to having the expert there, or there was only downside? I don't see it. It can only be good for the party.
I agree. I think maybe one counsel may have said, well, if you're there, then our weaknesses may show up. Well, I think if you own to those, and then that's really where that's where you can make it. You don't have to roll the dice. And so I'm a big believer, if you know what you're gonna have, and you don't have to show up to trial, and it removes the guesswork. Yeah. So long way of saying, I think there's only benefit in having experts, and to your point, Bob, whether it is the accounting economist or physician expert or other experts in the room, if that's what the case is based on. So I agree.
When you,
Well, go ahead, Bob.
well, I was going to say, when you don't settle and then you proceed to trial, does your mindset change? I can see you being more collegial and collaborative in a mediation, which is what mediation is all about. But then you go to trial, now you're in an adversary situation. Do you think differently in that context? Do you act differently?
Let me jump in on that one. When I'm in mediation, my objective is to assist in the facilitation of a resolution of the case. When I'm on the witness stand in the courtroom, I'm there to persuade, to assist the trier of fact and help the trier of fact understand the evidence. And at the same time, persuade the trier of fact, be it judge or jurors, that my opinion is the one that should be embraced rather than the other guy's opinion. So there's a different objective in the process. And I don't think mediation harms harms or changes the expert's approach in the courtroom.
Yeah, I was gonna say, and if there are mediation privilege issues, I think that could be a topic for another time. But that I think also comes into play. I've seen things change. Let's say mediation's too early and there is still discovery, then things do change at before trial. But you know, we are there, I think, to provide the analysis in an objective way, in an ethical way. And I think to Michael's point, you know, if all parties buy into what mediation is, yes, that we're there with a halo or an umbrella of reconciliation, and let's walk out of there and to resolve this so we don't have to have trial. But in trial, it is a different process, and we are there to provide our opinion and to, I think, explain it and to, yeah, I think persuade. But we do that through what we've done and how we've done it, and usually it just comes through as experts. So. Do we have any Q&A before we end?
I don't think we do.
I don't see any.
Now, in mediation, obviously it's collaborative, but do you ever turn on your persuasion hat, light bulb as well, and start trying to persuade the other expert or the mediator? How does that happen?
Well, I
Keep
think
in mind, oh,
go ahead.
In mediation is, in my experience, is not a forum. It's not a venue in which I'm testifying and I'm giving testimony with the intention of persuading the trier of fact to embrace my opinion. In mediation, you know, it's a process of bringing people together and working with those factors, taking the numbers that I've developed, the opinions that I've developed, the basis for the opinions, and working with whomever I have to work with in a mediation in the interest of bringing the people together to come up with a resolution. So it's a different enough form that I don't think in terms of persuasion, except when I took that other expert out into the other room and showed him the other evidence he didn't consider. And he persuaded himself that it was something that he needed to consider.
So then it would be accurate to say that the mindset in a mediation is more of a give and take on the part of the accountant, CPA experts. And of course, once you're done with that, you go into an adversarial mode where you're just 100% behind your position. Would that be correct?
we're trying to resolve the case in mediation, that there is give and take in the process of resolving a case. Every case, every expert will typically have certain pieces of the ingredients that go into his or her opinion. Some of them are maybe a little bit softer, may involve more judgment, and some of them are matter of fact. In mediation, the expert knows which of those are judgmental and is in a position to evaluate alternative looks at those pieces, at those ingredients and those numbers that go into the equation. So it's just a very different mindset.
And I want to add that, the numbers that we put forth in a mediation are generally the numbers. So it's not that it's going to change at trial, but I think it's an analysis on risk management. To Michael's point, which one of those soft areas that's more judgment will come to pass at trial, and what's the weight of those things? So if you're able to do weighted probabilities of what you think will happen, that's where the mediation comes to play, I think. And you're able to resolve something without incurring additional costs and living through the risk of whatever may happen at the end of a trial, which you can't control when it's a jury. It can go many different ways, from the highest to the lowest, or a number that you did not think of. So that's where I think we are there to inform. I mean, more so than anything else, I'm educating the mediator on my position. It's up to the opposing expert to do the same. And if we can reconcile that and say, look, odds of something happening or not happening is X, what do the parties think about that, and how do they want to act based on what they're seeing?
And we can't end on a better note than that. I want to thank everybody who's participating both live and in the Beverly Hills Bar Association Library, and particularly thank Michael, David, and my co-host Bob for what has been an informative and entertaining hour. Much appreciated, folks.
Thank you.
Thank you, everyone. Appreciate it.
Thank you.